Good morning, everyone, and thank you for having me. My name is Lam Chawei, a land expert in England and Wales. Today, I'll be sharing some insight into the functioning of our land registration system, with a particular focus on the mirror principle and to what extent it continues to serve its intended purpose in the 21st century. I will also offer my humble opinions of potential reform to the Land Registration Act 2002. So let's begin. Historically, land ownership in England and Wales was proven by the title deed, which is a piece of document privately held by the landowner to prove their title, with no central record. And this made the system prone to fraud, uncertainty, and dispute, especially as land transfer did not need to be in writing. Today, most of the land is registered under the Land Registration Act 2002, which replaced the 1925 Act. Ownership is now officially recorded by HM Land Registry, with each property given a unique title number and key details such as the legal owner and any right or registered that are clearly listed. And this shift have brought greater clarity, transparency, as well as security to land ownership and transaction. This modern system of land registrations is underpinned by three fundamental principles, which are mirror principle, curtain principle, and insurance principle. The mirror principle is a key idea in a registered land system. It means that the land register should act like a perfect reflection or a mirror of all the rights and interests that exist in a piece of registered land. By simply checking the register, anyone should be able to see who owns the land and what type of ownership they have, and whether any other person has right over the land that could limit the owner use of it. However, in practice, the mirror principle does not fully operate, even though under the new registrations RA 2002. This is because certain rights, which are also known as the interest that override, can still affect the land without appearing on register. This hidden right can be bind a purchaser even though they are not recorded, which create a gap in the mirror, and we will explore this right in more detail later. The second key principle that underpins the registered land system is the curtain principle. It is based on the belief that some type of right, called equitable interest, should remain behind the curtain and not appear on the land register. Equitable interests are rights in the land recognized by fairness and justice, equity, rather than by strict legal rule. Common example will be beneficial interest under a trust, where someone has the right to benefit from the land even they are not named on the legal title. This work is because of a legal process called overreaching. If a buyer paid a purchase price to at least two trustees, then any equitable interest in the land are shifted from the land to the money paid. This means that the buyer gets the land free from those hidden rights. For example, in the very famous case William and Glenn Bank and Boland, the wife had a beneficial interest in the family home. But because the purchase money was not paid to the two trustees, overreaching did not apply. Her interest still bound to the land and took priority over the bank, even though it wasn't on register. Last but not least will be insurance principle. This principle is based on the idea that once a title to land is properly registered, it is guaranteed by state. That means if someone suffered a financial loss because they relied on the register and it turned out to be wrong or incomplete, then they are entitled to statutory compensation, which also known as indemnity. In other words, the state will insure against mistake in the register. In conclusion, mirror principle means the register should show all the legal rights. That means what you see is what you get. The curtain principle hides certain equitable interests, for example, trust, as long as the buyer pays the right trustee. Insurance principle will provide compensation for mistake or omission in the register. As we mentioned, mirror principle should reflect the totality of the right and interest concerning a title of registered land. It should be like a mirror. In practice, the mirror principle offers significant advantages in the registered land system. At its core, it promotes clarity, certainty, and efficiency. By allowing purchasers to rely on the register as a complete and accurate record of the legal title and interest, it reduces the need for historical title deeds and simplifying conveyancing. And this support a faster, less costly, and also more secure property market. It also aligns with the broader goal of transparency in land transactions and will help prevent dispute by making the ownership and rights more readily verifiable. However, certain rights, which also known as the interest that override, can bind new owner even if they are not recorded on the register. This hidden right create a crack in the mirror. There are three main types of ITO. Here are right of occupier, short legal leases under 7 years, and legal easement. For right of occupier, to qualify as an overriding interest here, three elements must generally be satisfied. First is the right itself cannot be a mere personal right. It have to be a right in equity or law. And not all the land right bind third party. It's only the proprietary interest, like leases or mortgages attached to the land and are enforceable against future owner. In contrast, personal rights such as a license to live rent-free are enforceable only against the person who granted them and do not pass with the land. A proprietary interest can include an equitable lease, for example, as stated in the case of Skipton Building Society in Clayton, and also in Grace Reimer Investment and Wade. So the court in these two cases recognized that a tenancy by estoppel actually can amount to an proprietary interest. Secondly, they must be in actual occupation, as actual occupation is a question of fact, not law. This means that the court have to consider specific evidence such as what the person is doing on the land and how often they are there, and the nature of the property as well. Intention of the party is also very important to establish actual occupations. In the case of Thompson and Foy, the court ruled that Miss Thompson was not in actual occupation, as she had left the property with no intention of returning, and her physical absence, also coupled with her mental intentions, was enough to defeat her claim. However, if we compare with other cases, for example, Link Landing and Brewster, the court found that there was actual occupations because she had a strong intention to return to from an involuntary detain in a psychiatric hospital. Physical presence on the land is also a factor to establish the actual occupation. For example, there's a case called Mallory Enterprise and Cheshire Home. The land in question was derelict, but the claimant had fenced it off and visited regularly. The court held that the minimal use was sufficient to establish actual occupations, given the nature of the property. Similar in the case of Choka and Choka, which there's a woman temporarily absent due to hospitalizations, will still be considered in actual occupations because she intended to return and had belonging left at the property. And their occupation must be obvious upon the inspections or known to the purchaser at the time of disposition. So if the property reveals some evidence of another person's presence, such as like cloth, and this should be obvious on reasonable inspections of the land. Next, ITO will be short legal leases under 7 years. Legal leases of 7 years or less are also overriding interest, meaning they do not have to be registered to bind purchaser. This weakens the mirror principle because such leases may not appear on the register but still carry legal effect. For example, if today Alex buy a house subject to a valid unregistered 5-year leases, the tenant can still remain in the property and Alex is bound by that lease, even if he was unaware of it at the time of purchase. While the presence of a tenant might be visible, but actual occupation is not required for this lease to be override, making the register even less comprehensive. Last ITO is legal easement. It is a property right that allows someone to use another person's land for a specific purpose. For example, a right of way to cross their land by foot or vehicle. It can be override if they are known to the buyer, obvious on inspections or exercised in the past year. Again, this requires the purchaser to go beyond register and to inspect the land or make inquiry, which eroding the mirror principle in practice. There's a contradiction between the mirror principle and the curtain principle in the land law. The mirror principle says that the land register should also show a complete and accurate picture of who owns the land and what rights exist over it. But in contrast, the curtain principle allows some right to remain hidden from the register, such as certain equitable interests like the short leases, legal easements, or the right of someone living in the property are not listed on the register but still bind a new buyer. So this means that the register doesn't always reflect the full reality of land ownership, which creates a crack in the mirror principle while supporting the curtain principle. Additionally, the crack in the mirror principle can also seen expanding. This is because due to the category of interest of person in actual occupations, where the definition for actual occupation is not defined under the statute. Such expansion in the factor which can amount to actual occupation is a clear contradiction to the purpose of the ARA 2002 to reduce the categories of overriding interest. As the protections of such interests has been strengthened by court, which render the objective of the ARA 2002 impossible. Last but not least, it also can argue that the mirror is vulnerable because it somehow might contain error and fraud. While the insurance principle offers compensation for mistake, typo, and it shows that the system is not foolproof. The register can contain error, omissions, or be manipulated by fraudster forged document. Although the land registry has improved the security, but the cases of fraud still arise and victims can still suffer substantial losses or delay. So I would say that in theory, the mirror principle is a strong foundation of the ARA 2002, but in practice, it is compromised by hidden interests like overriding rights and the continued existence of unregistered land. So the reform may be needed to improve the transparency and ensure that the register truly reflects all enforceable interests. Now we will come to reform. The concept of actual occupation remains problematic due to its lack of statutory definitions. Although the ARA 2002 introduced improvement like the obviousness test and the need for discoverability on reasonable inspection, but the court still interpret actual occupation inconsistently, often relying on common sense and fact. For example, in the case of Link Landing and Worsted, the claimant was held to be in actual occupation despite being absent due to mental illness, and it caused uncertainty for purchaser. The suggested reform here is that Parliament should introduce a statutory definition of actual occupations and the definition of obviousness and lay down expressively the factor that the court is specifically have to consider. Also, the court should be guided by specific criteria such as the durations, regularity, and evidence of control or use. The second proposed reform will be amend the law so that only leases of 3 years or less will be overriding. This idea will make the law more consistent with the rule in the Law of Property Act 1925, which say that the leases longer than 3 years must be made using a legal document called deed. As a result, more short-term leases, which is over 3 years, will have to be officially registered, which will make the register more complete and accurate because it improves the mirror principle, since more interest will appear on the register, and it also will reduce fraud. At the same time, very short lease, which is less than 3 years or made informally, like through a spoken agreement, will not need to be registered. This means that they wouldn't overwhelm the system. Overall, this solution will strike a very good balance between wanting to include more leases on the official register and also avoiding the problem of overcrowding the register with too many short-term agreements. The third proposed reform will be targeted on e-conveyancing system. Already more than 2 decades, a fully operational e-conveyancing system has yet to be realized. Despite partial implementation, the model introduced by the ARA 2002 has proven too ambitious and, in some respect, impractical. The digital infrastructure necessary to support comprehensive e-conveyancing has not kept pace with the ambitions. Concerning surrounding fraud, identity theft, and system error remain significant barrier to full implementation. A more realistic framework for e-convincing should be developed. One potential solution is the use of blockchain technology, which offer improved security, transparency, and fraud resistance due to its immutable, decentralized nature. However, blockchain also presents a list of challenges such as a high energy use and scalability issue and regulatory uncertainty. So, I think that any shift toward the blockchain-based land registrations must also be supported by a list of legal and also technical research. Since there is so much of problem bringing by the interest that override, there's a question arise: should it be abolished? My answer is no. The call for the abolition were rejected by the Law Commissions, who stated that requiring individuals to protect their interests by registering them will be unreasonable. Why it will be unreasonable is mainly because some interests are too formal or personal. For example, a spouse living in a home without being named on the legal title may still have a beneficial interest in the property, especially if they have contributed financially or there was a mutual understanding of shared ownership. This interest is informal and personal, often arising through a trust, and many individuals are unaware that they should or they even can register it. Nevertheless, a considerable number of overriding interests remain as individuals refuse to follow this policy. It means that even though the legal system encourages people to register their property rights, but many people still don't, either by choice, lack of awareness, or practical difficulty. This is also because human rights should also be one of the consideration in the issue of overriding interest. Under the European Convention on Human Rights 1950, individuals are entitled to enjoy peaceful possession of their land without being deprived by the others. In conclusion, overall, while the Mirror Principle aims to provide a complete and accurate reflection of all interests in registered land, its effectiveness is undermined by overriding interests, unregistered land, and also some practical limitations. Although reform like clear statutory definitions, updated list rules, and also improved e-convincing could strengthen the system, but I would say that some hidden interests will still remain necessary to protect the vulnerable individual. Therefore, the mirror principle, true, is valuable, but it operates imperfectly in practice. Thank you.